Good morning, good afternoon, and welcome to our webinar on using mediation in commercial disputes. I'm happy to be the moderator of this panel, and we're hopeful that the panel and the discussion will provoke enough discussion for among the panelists and for the audience. Just a few homework questions. And one, the session, the webinar will be recorded for future references and posterity. We have a chat function which should be used to let us know the questions that the registrants, the attendees have, and we'll try to answer those in turn. We have, at least I understand, and correct me if I'm wrong, Demi, I understand that when the invitations were sent out, that there was a link to the bios of each of the panelists so that I can assume that the panelists can locate and find out about who we are and contact us in the event they need to do that. In the event that there is no link to the bio, there is at least sufficient information there for panelists to locate us. In any event, in the event that there is a need to write to us or locate us, please feel free to write us and we'll be happy to respond to any questions you pose. The same is true with respect to our sponsors. Nonetheless, I'd like to mention them. The first sponsor is the AMCC, the Arbitration and Mediation Court of the Caribbean, which is located in Barbados. The second sponsor is the Caribbean branch, the chapter, Barbados chapter of the Caribbean branch of the Chartered Institute of Arbitrators. And our third sponsor and our technical management for this webinar is the International Arbitration Center, which is located in London. Three of us on the panel, Wolf, Jane, and myself, are members of Int-Arb, which is located at the International Arbitration Center in London. We are chambers that have arbitrators and mediators. And our panelist, Barya Ahmed, is the founder of CADRIN, which is Caribbean ADR Initiative. Okay, and having said that, I think we should get started. And I wanted as a first question to raise a general discussion about why the use of mediation makes sense in commercial disputes. Barya, can you briefly describe what mediation is, or perhaps what it is not?
Sure, thank you very much, Calvin. Very pleased to be here with you all. Yeah, so mediation, what is it? It's a form of assisted negotiation. Essentially, the parties agree to appoint a third-party neutral who will help guide their discussions and negotiations and hopefully get them to a settlement by the end of the process. The third-party neutral, unlike a lot of the other alternative forms of dispute resolution, such as arbitration or adjudication, in the case of mediation, at least, in most circumstances, and there are obviously always caveats because it's a flexible process, but in most circumstances, the mediator does not make a decision or offer any advice or ideas about what the settlement should be. So they're there really as a facilitator to help the party parties in their negotiations, to perhaps allow them to think outside the box a little bit, because often, for those of you who have been involved in conflict of whatever nature, whether escalated or not, you'll know that sometimes it's difficult to see the wood for the trees, and having that external pair of hands, set of eyes, can help perhaps shift your perspective and your view as a party to that dispute. So unlike the court process, the mediation process is quite informal. It tends to usually take place over the course of a day, although in this new post-pandemic world that we live in, sometimes that does need to be shifted to accommodate for things that we hadn't anticipated, such as time zones, and that's fine. We are working, and we'll talk about this a little bit more later, but we're working more actively with the parties in advance of the main mediation itself, in setting up things virtually and making sure that they're comfortable. But really, other than that, it works almost entirely the same in person as it does online, which is that the mediator will allow the parties an opportunity in a safe, confidential environment to discuss their needs, their interests, to hopefully share these with each other to the extent that they might feed the possible settlement at the end of the process, and we'll work quite actively with them in reassessing risk, in considering the options, being creative with ideas, looking at what sometimes we label as expanding the pie before claiming the pie, and hopefully get to a resolution, which is then drawn up into an agreement, effectively a new contract, which the parties will sign and hopefully can at least live with. I wouldn't go so far as to say, you know, everybody will walk away happy, but certainly if they do reach a settlement, at the very least, it'll be one that they own rather than one that's imposed on them. So what it isn't is an imposed outcome from another source, such as the court or an arbitration tribunal.
Thank you, Baria. Wolf, you were in-house counsel for many years. Did you use mediation in your commercial disputes?
Thank you, Calvin. And Barry, I just saw that there was a question here from somebody who said a brief introduction from each of us wouldn't hurt. So I wonder, Barry, just quickly whether you mightn't just say something about your background.
Sure. So I'm a lawyer. I'm a recovering lawyer. Let's just call me that. I no longer practice, but I am a barrister, as we call it us in the UK. Predominantly, most of my work is now in commercial mediation, both as a mediator, but also as an international ADR consultant. So I work a lot with jurisdictions all around the world in introducing ADR, and particularly mediation, or refining the practice of mediation in those countries. And to that end, I have a very close relationship with the Caribbean, where I helped launch one of the sponsors for this event, which is the Arbitration and Mediation Court of the Caribbean, the AMCC, and stepped down about 2 years ago, and since then have set up another organization very much focused on building a better understanding of ADR across the region, which is the Caribbean ADR Initiative. So please find me online, and I'll be happy to answer any other questions that you have about me or my background.
Thank you.
All right. Jane, do you want to introduce yourself briefly?
Hello, my name is Jane Player. I was a commercial lawyer in international law firms for over 35 years. 2 years ago, I retired from being a lawyer to being a full-time mediator. I've been a mediator since 2000, and by 2 years ago, I realized that that's what I wanted to do as my full-time career. So I very much enjoy being now a mediator, a little bit like Baria, around the world. So I'm on panels in Singapore, in India, in Japan, as well as in Europe, and in London in particular. I'm based in London and do mostly commercial mediations from here.
Great. Well, then I'll just go back, Calvin, to your question. So,
well, before you do that, can you introduce yourself?
Yeah, I will indeed, Calvin. So as Calvin said, I was in-house counsel for a number of multinational companies based outside of North America, actually in Europe for most of my career. In the span of that career, dealt with a lot of our international disputes. So I'm a qualified mediator and arbitrator, and 5 years ago, I did leave corporate in-house practice to become a full-time arbitrator and mediator. And my areas of real interest are in international trade and investment disputes. So I very much am specialized in investor state type disputes. But going back to Calvin, to your question and the use of mediation in commercial disputes, as Baria so nicely put it, mediation in particular is important to business because it is a means for business to be able to maintain control over the outcome. As Baria said, if you go to litigation or if you go to arbitration, somebody else is deciding the dispute for you. So they will make a determination and the parties will then have to abide by that determination. And they haven't made that decision themselves. So mediation allows you, through the help of the mediator, to actually come up with a pragmatic business solution to your dispute. And perhaps equally important is that the relationship between the parties can often be maintained through a mediated settlement because you're working on the problem and solving the problem together. And you're coming then to an outcome that you both choose to come to. What happens, and I've seen it so often in a litigated dispute, is that the parties become fractured. They don't have a relationship any longer. They often become bitter. And at the end of it, no matter where you come out on the result, you often are dissatisfied and you probably don't want to be dealing with that other party any longer. And so mediation allows a means of continuing a relationship. It also allows you, from a commercial perspective, as Baria also said, to expand the pie. And that is so important in business because you can look at options to resolve the dispute far beyond the actual dispute itself. You can look at other potential contracts that you might have. You can look at different supply arrangements. It needn't simply be a financial matter. There might be other aspects, for example, licensing a product, that kind of thing that can come into the discussion in the mediation that you could never have if you were in a court dispute, because the court is simply interested in looking at the dispute the parties currently have and isn't interested in their future relationship. But mediation allows you to do that. So it became very much part of our practice. And we'll talk a little bit more about mediation clauses later, but to build mediation into our disputes clauses and to try to ensure that whenever possible, we did have a means of trying to bring mediation into the dispute resolution mechanism that we were utilizing. Of course, we couldn't always mediate all of our disputes because sometimes parties refuse to mediate. And in some situations, even where there was mediation, we might not be able to reach a settlement. But overall, it became our policy, our practice as a company to utilize mediation whenever possible. Calvin?
Yeah, Jane, you represented clients in many commercial disputes as outside counsel. When did you use mediation?
Thanks, Calvin. Yes, I did. In fact, My first experience of a mediation was when I was about 6 years PQE, junior associate or associate on a case, actually involved in the Caribbean. It was as a hotel build, and the construction company was Bechtel. And back in 1992, even then, Bechtel had a clause in their contract that said when they were in dispute with their build, they would always mediate it first. So as a junior lawyer, I went along with my partner and watched a mediation in action and participated. And I realized just how effective it was. For all the things that Wolf was saying, you saw that a project could go back and keep working. Relationships could be preserved, and frankly, costs could be saved. And so it was very early on in my sort of legal career when I realized that mediation really had a role to play alongside the law. And I say that because as an external lawyer, we like our cases. We're litigators and we like to fight and we like to win, and it's part of our DNA. And we always have the right on our side when we're fighting a case. But the reality is, as you get a little bit older and wiser, is that actually we learn that the law is not necessarily certain. It's not a science. The judge may decide against you. And I often sit as a mediator listening in the lawyers' rooms with their clients where they're both being told that they've got 70% chance of success. And I put it to them that one of them's wrong. One of them's going to get it wrong, and it's going to cost that client an awful lot of money. And if they could just hold that thought in terms of risk analysis, then maybe a mediation now, saving money, would be a good idea. And you have to also talk to the lawyers about that, because they will have budgeted through for a case. They will know what that's cost. And they're having to say to their client, maybe with funders on board as well, well, if we settle it now X and you spent Y already, is that a better deal for you than pushing it on, taking the risk that you might win or you might not, having spent maybe X times 5 or 6? So from an external lawyer's point of view, I soon learned that you have to be in collaboration with your clients at all stages along the case, looking at the risk analysis of whether you continue or you don't. Do you mediate early when you haven't got the evidence in front of you, perhaps, but you haven't spent much in terms of cost? Do you wait till you've seen disclosure, the witnesses, the documentary evidence, and maybe even the site, if it's a construction case, where you've got a much better idea of risk analysis, but then the cost is so high that maybe it's worth taking the risk and going to court? So you're balancing out at all times the cost of whether you pursue the case through to trial or you mediate. And we can talk about this later, but of course, you could always mediate more than once. So that's also an option open to you. So the law is not certain. It's always a risk. And we all know as litigators that the case that you're presented with by a client at the beginning of the case sounds super strong. You're convinced that the documents are going to be there to support you, and you're sure that the client has some superb witnesses. But life is like this sometimes, and when you look through the documentation, maybe it isn't quite as surefire as you think it's going to be, and maybe that witness is not quite as good, or the expert doesn't quite give you the absolute certainty that you're going to win. So risk analysis is always high on my agenda when I was a lawyer. The relationship point is also really, really important. Relationships for your clients in terms of their suppliers, in terms of their project team, and if it's a construction build, the future that they want to build, the opportunities they may get if they don't dispute it with, but also the relationship that we external lawyers have with our clients. If we are able to get rid of a dispute so that they can go and do what they do best, which is not litigation, so that they can focus their team on new matters and new projects, they're often more grateful to you than they would have been if they come with you, get constant battering by us external lawyers asking for time when they least want to give it to you on cases which are historic as opposed to their new projects, building up the litigation. The relationship build you have with your client in being pragmatic with them and thinking about settling through mediation is also strengthened. And I found as I worked through my 35 years as an external lawyer was that the cases that I settled weren't necessarily just a stop in revenue. They were actually a relationship build such that they trusted me for the next case and the next case and the next case. So I ended up being a trusted advisor, someone who was willing to say, we should settle this one, as opposed to we should fight it all the way through. So relationship worked for my client and myself, as well as the relationships that my clients had with their suppliers.
you've got the microphone, Jane. So let me ask, at what point in a dispute does mediation work best? What is your experience as an outside lawyer?
Well, you can use it pre, during, or post, or even after the award. There's no prescription as to when you'd use a mediation. As I mentioned earlier, obviously, if you mediate it early, the advantage of that is you haven't invested costs and you possibly haven't broken relationships quite completely yet. So you've got a good chance of being able to mend, maybe even put a project back on track and keep going. But you haven't got the evidence. And sometimes the lawyers are nervous about that. We all like to know really how strong our case is. And it's very difficult to advise a client based on not seeing all the documents or not having spoken to all the witnesses. So it's a risk, it's inevitably a risk, but the costs are low and therefore the outcome can be quickly secured at least cost if you do it pre the dispute. You can always do it pre-dispute, and then during dispute, you can also have a think about issue mediation, which is a growing pattern we're seeing, where there may be one or two really key points that you're at loggerheads with your supplier or your customer, and you want to understand in a safe environment without prejudice what their arguments are against your current position. So you could suggest a mediation simply to look at one particular issue that might actually unravel the whole dispute or may simply give you a better view of risk analysis. And I've also seen people mediating even after the first post decision of a judge, where quantum perhaps has not yet been resolved, in which case you have got your judge's view on the liability, but not on the quantum. And you can then sit down and work out whether you want to mediate the quantum. Or you may find that someone has logged an appeal, in which case you are working out whether it is worth at this stage cutting your losses and looking to try to mediate rather than have to re-argue your case before the court. So the answer to your question really, Calvin, is actually you can do it at any time, and you can do it as many times as you want to, and you can do it just on individual points, not just on the whole thing together. And that's the reason why I'm such a big fan of mediation, because frankly, it can fit your fuss. As an external lawyer, you should be using mediation as a very flexible tool alongside the litigation or the arbitration that you're looking at with your client, and using it as a complementary application as opposed to something which is an alternative.
And the processes aren't mutually exclusive. I agree.
No.
Wolf, how did you evaluate the right time for mediating from a business perspective?
That's a great question, Calvin, because I think within a business itself, I mean, mediation, as Jane was saying, can be utilized in so many different ways. I mean, as Baria said, mediation is a facilitated negotiation. I mean, negotiation is something that businesses do all the time, and the business people are probably best suited to a negotiation. But there are always barriers that come up in communication, and this is where the mediator can play such an important role in helping to facilitate the conversation between parties. As Jane said, even at the outset of a project, maybe when you're just developing the project and maybe starting to discuss contractual terms, there are often situations where you reach an impasse and it may not be possible for the parties actually to look beyond their own interests. And so that kind of deal mediation is something that's becoming much more popular. So you can actually bring in a neutral, and that's all it is, bringing in a neutral to help to facilitate the discussion. Maybe that person has a certain expertise in that particular industry, and so can help the parties then to structure a better deal than they might have been able to structure themselves. So there's no there's no magic in it. It's when you feel it would be of benefit to the parties to actually bring somebody in to help them with that discussion. I mean, one of the areas that we're not directly discussing here today, but that has become increasingly important are dispute boards, where you've actually built into the contract a group of people that will help you deal with issues as they arise during the performance of a contract. That's very similar to actually mediation. And in fact, there is project mediation where you have somebody who is a mediator that's involved in the project all along that can help you then to discuss issues where there is an impasse between the parties and help facilitate that discussion. We'll talk a little bit more about step clauses, I think, a bit later, Calvin, but one of the ways to ensure that there is mediation at a certain point in time is to actually write it into the contract. So there is a contractual provision that provides for it. There was a question that somebody asked about the advantages of using mediation over arbitration and what are the deciding factors. Well, in fact, I think, Calvin, as you just said, I mean, they're not mutually exclusive of each other. Mediation is something that can be attempted prior to litigation or arbitration, even if you have arbitration in mind as the ultimate resolution mechanism, you can still use mediation prior to that. And so Med-Arb, as it's called, is something that is increasingly popular, where you have mediation prior to the arbitration. And if the mediation fails, you proceed with the arbitration. So I don't want you to look at this as being exclusive of each other. It doesn't mean that you can't utilize arbitration if mediation fails. So mediation is something you will utilize to try to find a resolution along the dispute path as the dispute evolves. And you're hoping at some point, as Jane said, you can utilize it more than once. It's a process which is an informal process. It can be utilized at any time. Often the trick, though, is to ensure that the other party or parties are willing to mediate when you're willing to mediate, and that's probably the biggest issue that you will face. And that's why I think in a discussion of whether you include it in a disputes clause, you have to take that into consideration. Calvin?
Yeah, and if done in good faith, it is a wonderful tool to be able to have the parties refashion, if you will, their business model rather than wait for litigation. Arya, what has your experience been when a dispute is at the courthouse? The parties are headbound for litigation.
Yeah, I mean, as a barrister in the UK or a trial attorney in the US or other parts of the world, you know, one of the things that you're trained to do at a very young age, as you're coming up through your legal practice, is to settle cases at the court door, right? So you negotiate those settlements right before you're about to appear in front of the judge. And I think mediation, the late mediation, is similar, except that you have this external pair of hands who can come in and like I said earlier, hopefully allow you to view things in a slightly different way. I've done a lot of mediations as mediator, which have been quite late in the escalation of the dispute through formal processes, whether it's court or whether it's arbitration. And a couple of examples that might be of interest to the audience. I did an employment dispute, which was just about to, in the UK, just about to go to tribunal. It was a discrimination case involving a very senior employee within a bank. And, you know, there had been a lot about this particular matter in the press. And I think it needed to be mediated late because the parties and their views were so disparate, and they needed time to express those to each other quite forthrightly in some of the communication between them. And they needed time to see the witness statements that they were going to be producing, to really look into the abyss and then say, actually, we want to own the outcome here. So protecting their reputation for the bank in particular, having the opportunity for the employee to walk away with something that she could not only live with, but would allow her to continue her career from a positive frame, as opposed to with the court litigation and the outcome, potential risk of that outcome affecting her. So from that point of view, it made sense for them to mediate when they did, and they achieved a settlement. Similar, different sectors, similar sort of situations. I did a 10-party, it was 3 mediators. We worked in tandem with 10 parties, and it was a partnership finance case with a bank who had brought individual claims against 9 persons within a partnership which had come to an end. And there were lots of interesting elements to this particular case, but because the case had been going on for 20 odd years by the time it came to mediation, and it was about to go to the appellate court, it had gotten to the point where some of the defendants that the bank was claiming against were so aged, and some of them were actually really quite ill, that proceeding through the formal court process was going to be quite difficult for them to, 1, set up, and 2, deliver. So it was decided that they would mediate. They appointed 3 mediators. We conducted mini mediations between the bank, and the 3 of us would then get together and say, this is where we've gotten to. It allowed for a couple of the parties, the defendants who were a little bit older and had health needs. It allowed us to set up a process which was respectful for that, and allowed them to engage. And even though it was very escalated, having had a first round decision from the court and now going through the appeal process, after 3 days of mediating, we got a settlement on all 9 cases. So there are occasions where I think that even though the dispute and it's the way that it has been run through arbitration or mediation has been escalated and a lot has been done, actually there's a real value sometimes in the late mediation, because the parties have worked out their risks. They have got the data that they really need to help them make the decision. And now it's just a matter of getting together and talking it through. And the mediator helps those communications. So so it can have a really positive outcome, even where you think actually this case is the only way out here is somebody to make a decision.
Before you put away the microphone, Barry,
Yeah.
what would you say? There's one question about court annexed mediation.
Mm-hmm.
Can you give us some of your thoughts with respect to court annexed mediation?
Yeah, I mean, in the Caribbean in particular, there are, some examples of very effective court-connected and court-annexed mediation schemes. So, for example, the Eastern Caribbean Supreme Court has a scheme which has been running for a long time. Barbados now has a scheme which has been running for a few years. And like I said, they're very effective in that they're being utilized. There are reports which are being produced. There's a range of different types of cases which are being referred. Certainly for lower value disputes where going through the court process is going to be difficult or a deterrent for certain types of parties, they make a lot of sense. And there's no reason why the parties shouldn't utilize that service if it's available to them. There is, I think, where there is an opportunity, and I wanted to pick this up later when we talked about developments in the Caribbean in particular, but I think there's an opportunity for courts to do more. And I see in the question that's been posed, there's this a question around mandated mediation and making parties mediate as a pre-step to something else, whatever it might be. And in contract clauses, that can sometimes be the case. So they agree a contract clause, a tiered contract clause, which says mediation will be the first step. In certain parts of the world, in Canada, for example, in Australia, you have mandatory mediation as a first step in the litigation process. And while when that was first introduced, many of us had our reservations about, the way that parties might engage in a mandated process. Actually, the outcomes and the strength of the mediators' participation and the impactfulness of that extra pair of eyes, new set of eyes, speaks for itself, because mandatory mediation still has very high settlement rates, and it allows the courts to screen certain types of cases and say, actually, these cases can be settled by the parties. The outcomes will be more powerful for them if they were to resolve this themselves. And the court's time isn't taken up dealing with matters which could be dealt with by the parties themselves. So yes, that would be my response to that.
Well, that's a terrific segue into my next set of questions. And the first one has to do with, should mediation be built into contract clauses? Wolf, you alluded to this factor. Indeed, so I'll let you have the first question. And what is your view when drafting commercial contracts with respect to including mediation clauses?
Very good, Calvin. And that's a little bit, as Baria said, like the mandated mediations, where the court or legislation mandates that you first have to mediate a case before you can move on to the next step. So this is just commercially agreed between the parties that mediation will take place before you can move on to arbitration or litigation. And you can speak to different commercial lawyers in-house or outside who will say to you, well, that's not such a good idea, because then you're actually forced to mediate at a stage in the dispute where perhaps it's too early to mediate. As Jane said, some lawyers, in particular outside lawyers, will say you first have to get enough facts, you first have to speak to witnesses, you first have to develop the documentation until you really know what the case is about, and only then can you mediate the case. I think that that argument has now really fallen much by the wayside, because as people began to understand the mediation process and what the benefits of mediation itself are, there were good reasons to mediate even earlier, as I discussed before, the whole question of relationships. So if you can bring in somebody at an early stage to deal with an issue before it really escalates in the dispute escalation phases, then you actually have a better chance of settling it. I mean, once you've spent a lot of money on discovery or developing the documentation and facts, it becomes harder, because you already have then a fair amount at stake just in the costs, be they the outside lawyers' costs, the internal costs of the company, and it almost becomes self-fulfilling that you have to then go to trial in order to try to gain back, some of that expenditure. So looking at it from a practical commercial perspective, you'd say, well, I mean, if we can try to mediate this earlier, it's got to be overall to the company's benefit. And so our view was, you do have a stepped clause, so a tiered clause where you would have a number of steps that you go through, whether it be escalating the dispute to a more senior level of management, and if that didn't work, that you would then go to mediation, and if that didn't work, then to arbitration or to litigation. And that's quite common now. I mean, most companies will have that type of tiered clause. And even if you can't resolve it at the first mediation, there is always the possibility of further mediation. But more important than that, and I've seen it both as a user and now as a mediator, when you see the parties actually speaking to each other and explaining their positions to each other, particularly if it's the business people that are speaking and not just the lawyers. You'll start to see that there is an understanding that grows that perhaps the other party also has a position that should at least be heard, if not agreed with. So what that means is that in the mediation process, you've got the decision makers involved. That's key. I mean, the decision makers are there at the table. They may not have been the people that were involved in the actual project itself. So you've already elevated it to a different level of management, perhaps. And those people are actually first coming to understand at that point in time what this dispute is all about, and hearing it from their counterparty, and perhaps also then learning about the legal position that the other party has. They suddenly realize that, as Jane was saying earlier, they don't necessarily have a 100% case, because nobody has a 100% case. And they start evaluating the business risks involved in continuing. And they all of a sudden see that perhaps there is a better way out. Maybe not at the end of the mediation. Maybe they don't reach a settlement at that point, but they're already, that grain has already been planted, that seed has been planted, where they start to think about resolution more seriously. And at some point, before you get, as Barya said, to the courthouse door, they are going to resolve that case. They're going to have a much better chance of resolving that case if they've gone through mediation than if they hadn't gone through mediation and it were just the lawyers trying to negotiate it at the courthouse door, because there's a much better understanding by the business people of what the dispute is all about. So my view is, yes, put that into the contract clause, because that way you will ensure that you do get a mediation, because most courts will apply those clauses. And if you haven't gone through a step, they won't permit you to go on to the next step. So put that in there. That will ensure that you do get a mediation at a point in time where there's a dispute and you might not be able to convince the other party to mediate. So my view is you'll get more benefit out of putting that clause in your contract.
And indeed, one of the additional advantages I find is that the parties are able to reduce the issues that are in contention, so that if they do end up in arbitration, for example, you would have reduced a number of those issues that are now being put to the arbitrator, which has an effect, a positive effect in cost and time. Barya, you're a friend of the Caribbean, and you know exactly how mediation is conducted in the Caribbean, having been at the AMCC and having set up that institution, or at least largely responsible for setting up their infrastructure. You also are familiar with other regional institutions. Do these institutions have contract provisions that can be used?
Yeah, there are a number of, obviously now ADR institutions across the region, and some are focusing only on arbitration, like the BVI-IAC, at least for the time being, and others are full service ADR centers, such as the AMCC, which offers mediation, arbitration, and other forms of alternative dispute resolution as well. And certainly for the AMCC, I can tell you that they do have standard model clauses for ADR. I can tell you that because I drafted them. So at least up until I was there, and I'm sure they are still there, they're available online for people to download. With the other entities around the region, I know that in Trinidad, for example, a couple of the mediation centers there offer standard clauses. There's a new center about to be launched in Guadeloupe, which, and I know I've been talking to them, and I know that they're putting together some model clauses for inclusion. point about model clauses is that you can access a bunch of them from all over the world. You know, international ADR institutions everywhere will make something available for any parties, any lawyers who want to access some wording, including UNCITRAL, you know, as one of the big ADR sort of gold standards internationally. The real consideration for the parties, and you know, it may be that at the point that they are drafting an agreement, they want to be clear about the monetary considerations which may impact them if a dispute does occur. It may be that because of the nature of the agreement between them, confidentiality, even at that early stage, even at a point where disputes haven't actually come up, but that confidentiality will be crucial. So let's say, you know, a government contract for a construction, a key infrastructure development, confidentiality is always going to be, you know, important to those parties. So it doesn't matter what the reasoning might be or the rationale might be behind putting in an ADR or a mediation specific clause. I think the consideration in some cases, in certain types of cases, and I know Jane is going to talk a little bit about how we should draft these types of clauses or step clauses, as we'll refer to them. And I think one of the considerations is if you're working in a certain type of sector, or if you have a certain type of agreement, then you want the clause not to limit you, because that is actually a bad thing for mediation and its development. So for example, if an injunction is likely to be required because there is certain type of information which the parties are sharing with each other under a license agreement, so protected intellectual property, and if a dispute occurs, an injunction might be required. In that circumstance, you don't want a clause to block one of the parties from being able to make such an application, in the same way as you wouldn't want that if arbitration was to happen, because there are time restrictions or anything like that. So that's one of the things I think it's worth bearing in mind for, certainly for large scale commercial projects, and those types of cases. But in most circumstances, in the Caribbean, for example, I think the figures are something like 70% or over 70% of businesses conducted by small and medium enterprises. And they're entering into contracts all the time, and protecting themselves from loss of time, energy, all those things that Jane was talking about, protecting themselves possibly from the costs and reputational damage, which might go hand in hand with a court litigation process, the length of time it can sometimes take to get an outcome through the court processes, and also obviously not the loss of the opportunities that they're missing elsewhere by focusing on the dispute here. You know, for small and medium enterprises, particularly in the post-pandemic world, it's more and more important to protect yourself. And one of the ways that you can do that is as you enter the contracts to see whether an agreement, at least as a post-negotiation, pre-litigation arbitration step, you can include mediation as a step to at least attempt.
Wonderful, thank you. Jane, what advice would you give on the scope of the arbitration clause? How broadly the arbitration clause, the mediation clause, how broadly should they be drafted?
It's a really good question, and it's quite a knotty question. And I see in the chat that someone's asking about how good are lawyers in the mediation process. And I will say actually nowadays, so much better than they used to be. And whilst we can criticize the litigation, red in tooth and claw lawyers who want to fight to the death, we've also got to be cautious about the commercial lawyers, because, and I'll say this as a lawyer myself, lawyers are pedantic. We need to get things right. We need to get things perfect. So commercial lawyers, yes, please, let's have a mediation clause. Let's have a step clause, as Wolf mentions, but be really careful that you don't try to imagine every single scenario and have this clause that goes on for pages where you've tried to predetermine what's going to happen in any eventuality, because you won't be able to. I mean, who would have known a year ago COVID would have been such a massive thing for us internationally? You just don't know these things. So my cautionary tale is for all lawyers who are drafting, yes, please, let's have a clause, but don't try to be too prescriptive. So for example, in a major project, you might see in a contract that IP disputes have to go to an expert determination, but commercial disputes have to go to mediation and an escalation clause, and financial disputes have to go somewhere else completely different. But the reality is, as most clients will tell you, the disputes are disputes, and they may have a little bit of finance in it, and they may have a little bit of practical commercial decision making to be thought through, and there may be a little bit of IP in there too. It may be someone's design that they're working on. The reality is, you'd actually prefer it all to be discussed in one forum, not have three running in tandem. That would be even more expensive. So my plea, in my experience, having done a lot of this drafting and been, the wrong end of looking at clauses where you then have to decipher it when the dispute has happened, is yes, have the clause, but don't make it too specific. Make it as open as you can, not so it's be interpreted for those who are not wanting to avoid mediation, but so that everybody has an opportunity at the earliest stage to turn around and say, should we not just sit down and spend what we know is about 1/10, if not 100th, of the cost of a litigation or an arbitration, looking at mediation for one day to see whether we could not get this sorted out. That's what you want to give your clients the opportunity to do. It may not always happen, but we know over 80% of mediations do succeed in settling cases. So why wouldn't you have a best chance for a client to be able to look at the dispute from a mediation point of view first? So I would definitely encourage mediation clauses in an escalation clause, as Wolf suggested. But another mention on the chat is around regulatory or competition cases, and there will always be examples where, as Baria says, you need to get an injunction. You'll never be able to stop somebody being able to go to court for that. And sometimes if a regulator is involved and a complaint's already been made, we have to recognize the limitations that a mediation will not be able to stop a fraud trial, will not be able to stop a police investigation or a regulator who's already been given the papers. What you can, of course, do in a mediation is settle something on the basis that you might cooperate together, or you might provide documentation that assists in a health and safety investigation, for example. But we have to be sensible about what we're facing. If we're facing a commercial contractual dispute, you'll be able to settle the lot. If there's an alongside FSA, FCA, regulatory investigation going on alongside it, we have to recognize how you're much better off if you're not fighting on two battles, you're only fighting on one against that regulator with the support of your supplier, your customer, or your partner in the business, rather than actually having them perhaps fuel the investigation against you.
And I would add to that, one of the advantages of using contract provisions that are developed by institutions is essentially that, because they're tested to the point that they have the flexibility to include, or at least an expanded scope of disputes can fall under the clause without trying to identify each and every potential dispute that arises. So one of the advantages of using clauses that are recommended by institutions is essentially that these clauses are properly tested.
Yeah, and I would say to that, actually, Calvin, that most institutions will offer a number of different types of clause, and the clauses may have differences in terms of the procedure that's laid down. They may have differences in terms of triggering mechanisms, and the parties can pick and choose the right clause for their individual contract. So they can pull in stuff from different, even from one institution's model clauses, they can pull in sub-clauses from different elements of those model clauses to make it work for them.
Okay.
I note, Calvin, sorry, there is a question about cases where courts are not recognizing mediation clauses, and maybe that is a particular issue, I don't know, Calvin, in the region, but generally I would say my own experience in many different parts of the world is that courts are quite supportive of mediation and generally will enforce these mediation clauses before you can go on to the next step. So there may be isolated situations where that hasn't happened, But overall, I think courts are quite supportive.
Yeah, well, I can foresee, not that the courts aren't recognizing the mediation clauses, but in the event, the circumstances, the acts and/or omissions of the parties may very well lead someone to perceive that it's fruitless. It's not beneficial to pursue mediation, given the antagonism or the aggression one of the parties may have demonstrated towards using the process, that the courts may very well determine that it's a waste of time to try to attempt mediation. But I do not see a court out of hand disregarding the parties' intentions to use mediation prior to going to litigation. I've never seen that, but I have seen where courts have concluded that it was, given the facts and the circumstances of that particular dispute, it was futile to go to mediation.
But that's the concern, isn't it? Because I think it's getting less and less, but I think we are educating our judges more and more now to understand what mediation can achieve. And if you've got a judge who doesn't know enough about mediation, he might think just that. I mean, the amount of cases that we mediate where there's a huge amount of antagonism, but that's the very reason why mediation is needed, to try to bring that tension down so that people look at it in a much more pragmatic way. And I think one of our participants mentioned, well, what if the court forced mediation pre-dispute can be very helpful, because just as Wall says, one of the big issues with mediation, because it's consensual, is that both parties have got to recognize that it's time to mediate. And one might say, no, not yet, I want to see all your disclosure first. And the other might say, well, actually, I don't want to spend more money on disclosure, I want to mediate now. If you have a court saying you must at least try mediation before you issue proceedings, that's quite a neat way of forcing people to the table. They can't make you settle, but they can at least make you think about settlement. And that might well help you, if you can't settle it completely, direct your attention to the areas where the other side are clearly most concerned. And it will give you an indication as to what's really underlying the dispute. Because I often think we will never know what motivates people to go into litigation. We think we know. As lawyers, we think we know because we're being told by the client, but you never always know what all the motivations and needs are of the parties on both sides. And that's why mediation works so well, because you peel the onion, you look inside to work out what really has motivated people to get into dispute. So I think I'm a bit conflicted when it comes to court-enforced mediation, because whilst it goes all against the grain of a mediator who wants to bring the parties consensually together, I can see the benefit in at least forcing people to address the issues, if not settle the matter. And sometimes court-enforced mediation at that early stage is very useful.
Okay, the panelist, Jamila Ali, describes that there is a case in Guyana where a contract party went straight to court without any pre-action or mediation. And so far, the courts have upheld it, saying it's not a mandatory clause. I don't know the circumstances. It could have been that the person, the actor going to court, the respondent did not invoke the jurisdiction of mediation, and as a result may have been deemed to have accepted the jurisdiction of the courts. I don't know the circumstances, but I would think that courts would normally recognize the parties' intentions to want to mediate prior to going to court. So as I say, I don't know what the specific circumstances are.
Yeah, one of the areas, Calvin, and this actually does raise an important point, and Jane touched on this when drafting the mediation clause. So just when drafting the stepped clause in particular, one of the things parties do have to be aware of is time limitations for moving from one step to the other. There have been courts that have criticized these clauses where there isn't a clear delineation of when you move from the negotiation step to the mediation step to the arbitration step. And those clauses have sometimes been struck down because they're not clear. So if you are drafting these, you should make clear that there's a time period at which you then move to the next step. Otherwise, you might run into the situation that's described here.
And I think that's really what the question's going to. So you're absolutely right, Wolf. So what you would normally say is you have 90 days or 60 days to negotiate. And if that doesn't work, you fall into the mediation time period, and then you have 90 days to set it up. And that stops a recalcitrant party using it as a device to delay, exactly as Wolf says. And so if in 90 days you haven't been able to agree a mediator when you're going to mediate and get on with it, then you know you fall into the next stage, which is litigation or arbitration. So it is useful to have a process whereby you know where you're going. But I can see how a court couldn't force you to mediate. They can force you to give it a go. And in the English courts, we have a protocol, we have the CPR, which says you must consider mediation, you must consider it seriously. But no one can force you to do it. We have cost consequences. And if you can show that you seriously considered mediation, but in your view, you decided that it was not going to work for rational reasons, a court might well uphold it. So we, both Wolf and I, know of a position where a party refused every single stage to mediate, but made a Part 36 offer before the hearing started. And whilst we complained because there was no mediation despite asking a number of times, the court there held that the consideration of it and then the Part 36 offer was as good as. So we have got a situation where courts are not always going to say, you must mediate, and if you don't, there will be consequences. And we've got to recognize that in different jurisdictions, different courts and different judges within each jurisdiction will have different views as to whether a mediation would have been a success.
All right. I wanted to spend some time and at the spotlight on mediation in construction and hospitality industry disputes with a particular emphasis on the Caribbean. Now, many of the governments have strongly encouraged parties to seek to resolve any emerging contractual issues responsibly through negotiation, mediation, or any other alternative dispute resolution mechanisms before considering litigation. We've touched on a number of the benefits of so doing, that among which include parties can be able to fashion a new business model arrangement if they do try to mediate rather than go to litigation, where the outcome might not very well be of their liking. So that mediation does afford you an opportunity to do that. Barrier, what do you see as some of the COVID related disputes that will arise in the region? Because a lot of these COVID disputes, I think frustration of contract, force majeure, all these different areas may or may not have clauses that address those. And if they do, may not properly address them. But in any event, you don't know how a trier of fact will determine how they should be interpreted. Whereas mediation of the disputes may allow parties to consider those eventualities and indeed arrive at some form of a settlement that is agreeable to both parties. So what do you see as some of the COVID-related questions that will?
Yeah, I mean, it's obviously very topical, and it's topical around the world because unfortunately we are now in a reality where the way that we work, who we work for, is all being impacted by circumstances outside our control. In terms of what may what I imagine is already happening, but what I imagine will escalate in places like the Caribbean region are employment related issues. So all over the world, we're seeing, you know, the impact on economies from the pandemic. People don't have the same employment or job security as they have had in the past, and particularly in the Caribbean, that is, excuse me, a large number of people work within the hospitality or tourism sector, and that sector is, for want of a better term, taking a battering when it comes to how much it's being affected by COVID. So if people are losing jobs, if people are being laid off, then I imagine not only are they going to be disputes, but I also imagine that they're going to want quick resolutions rather than waiting for the courts to make decisions on potentially hundreds, if not thousands, of similar cases. So there's an opportunity, I think, for regional centres, for regional ADR providers and regional mediators to step forward and say, look, let us help. Whether it's large companies such as, I don't know, insurers or tourism sector employers, working with them to see if schemes can be set up to manage high volume cases, or whether it's, you know, individually going to individual organizations, big commercial firms, and saying, well, how can we help? Beyond that, within the, and Jane and Wolf both talked about this, but there is going to be an impact to infrastructure and construction across the region, whether it's infrastructure and construction focused within the hospitality or tourism sector, or whether it's just infrastructure with a view to improving, you know, local amenities and availability of and access to residents. So if those, as you said, if force majeure is claimed, if, you know, if they are frustrated, as you said, Calvin, then how do you manage that situation so that the impact isn't long term, to the point that perhaps those projects have to be vacated? Is there a way to agree with the help of a mediator some process which will allow them to continue working, potentially with a longer timeline, shifting some of the parameters that were agreed in the original contract, etc. And then finally, and I come back to the point that I made about, you know, the Caribbean being an odd place in terms of the region itself, because so much of the business that's being conducted regionally is being done by small and medium enterprises, these SMEs. And they face a real challenge right now, whether it's through, you know, with banking and finance and trying to get themselves to stay afloat, or whether it's because they can't either get the contracts or deliver the services that they've been set up for. So there are opportunities in those circumstances as well to try and limit the damage that they might potentially face by allowing them quicker resolutions, cost-effective resolutions through a mediation process.
Wolf, how effective is mediation as a tool in restructuring contractual relationships?
Yeah, I think, you know, just following on what Baria has just said, again, mediation, we should remember, is actually a facilitated negotiation. So the parties are negotiating with each other, but through the help of the mediator. And one of the real strengths of mediation is that you can get all interested parties around the table. So it needn't simply be the supplier and the purchaser of goods, for example, because in the COVID situation, what we're looking at really is legal obligations that have been agreed that have been impacted or prevented from being honored to the degree set out in the contract through no fault of the parties themselves, but simply because of the circumstances. So the fact is that there may be other parties. There could be a bank that's financing the purchase of these goods that's involved. It may be the import-export company that's actually bringing the goods into the country. It could be a whole number of different parties that are involved in this transaction that the contract calls out. and so mediation allows you to bring all of those people around the table to discuss the best way of resolving that problem. Something the court can't possibly do. The court can only award perhaps financial compensation to one party that can demonstrate that the contract has been breached, but that doesn't help you in this particular situation, the types of circumstances that Barya was talking about. You want to be able to resolve an issue pragmatically now in the most cost-effective way, maintaining that relationship so that you can still continue to do business with that supplier, with that bank, with that importer. These are all critical to your future as a business. So you want to be able to deal with that now. And I think, mediation really provides the best opportunity, particularly for SMEs that are in a crisis of survival right now, to try to move forward on whatever that contractual relationship is in some meaningful way that will allow them to remain in business. And so absolutely, from a commercial perspective, I really see mediation being very useful in the current COVID situation that we find ourselves in.
Okay. This one's for you, Jane. Confidentiality, speed, and costs are all important factors in dispute resolution at the moment. So are parties using mediation to resolve these COVID-related issues?
Yes, they absolutely are. And I saw a question being raised on the chat about enforceability. And obviously that's just as important because, look, the government's making decisions and changing regulations all the time at the moment, daily even. And we're all watching our news. All of our governments are doing it. One minute you can't travel, next minute you're going to self-isolate. It's a nightmare for individuals, let alone for businesses. And every sector has to protect itself, whether you are the pub or the hospitality, the hotel. You've got suppliers for food, for drink, for accommodation, for cleaning, everything, the linen. Every contract will have an impact on this. If you're in the airline industry, whether you're the travel company or whether you're the airline itself, you've got endless issues arising on a daily basis, which nobody had predicted we'd have to be dealing with. And again, if you're in the construction world and you're building a golf course, you're building infrastructure projects, you can't just stop everything because of COVID. And it seems to me that actually there's what I would call in some ways commercial desperation for some parties. For others, let's be realistic, it is also opportunistic for them in a tactical way to be able to bring back to the negotiating table projects which could be better negotiated in these circumstances. And there are very, very few ways in which you'd be able to get people together quickly in this such a dynamic, it couldn't be a more dynamic time, to get people together quickly in a confidential process whereby you can, in a safe environment, try out a renegotiated contract that might be able to maybe pause the project just for 30 days to be able to get better financing, a different contractor on board, a different way of working, formulate a better deal, a deal that will keep people alive financially during this crisis, that will be able to renegotiate with landlords or renegotiate with banks to be able to keep the finances flowing, to allow that project to complete, knowing as we all hope that this time next year things will be an awful lot better. Once you've got your mediated settlement put together, helped by a facilitator who's listening to the confidential needs of all the parties, then you put your contract in place. And then what you want to know is that you can enforce it. And we all now know that we've got the Singapore Convention, hurrah for that. It's only recently come out, but there are a lot of signatures to this. Or possibly you work with the arbitration community such that you've got an arbitration on foot. You do a negotiated confidential settlement through mediation that allows you then to go back to your arbitrator and get yourself an award, which we then all know could be enforced through the New York Convention. So we've got to be flexible, we've got to be dynamic, and we've got to act quickly. And what better use of mediation than in this confidential process, getting you a contract that everyone can live with. And as Baria says, nobody will be punching the clouds and saying, yippee, I've got a fantastic outcome. But you've got an outcome where people survive. You've got an outcome whereby businesses continue, and you've got an outcome that everyone can live with. And that must be the way to go forwards in this crazy, crazy environment where no one really knows from one day to the next where we're going to be. Let's use mediation to help businesses keep on their feet for as long as possible with flexible processes.
And I think your reference to the Singapore Convention is the response to that question that you referred to in the chat about.
Can I also I'd also raise a point about even before the Singapore Convention, and Wolf and Jane will no doubt have experienced this. We were all mediating cross-border disputes long before the Singapore Convention came into place. And actually, I can only think of one case, and it wasn't an international cross-border case, where the parties, after having reached a settlement, said, we've made a mistake and we want to renegotiate. Actually, one party said that, the other side said, well, you've signed an agreement and now you're bound by it, and it was in the UK. But it's very rare that where the parties have come to an outcome, to a decision themselves with the help of a mediator, it's not enforced in the way that a court outcome or an arbitration outcome award might be. It's very rare that they'll go back on it. So it's, you know, as much as, yes, it's great to have the Singapore Convention, and it's great that we have so many signatories, and that now mediated settlements do have that second tier of protection. Actually, that sense of ownership that the parties have for the outcome that they have gotten to and the agreement that they have signed to means that it's almost never happens that they won't perform against that agreement.
I'd agree with that. My only caveat to that is set up the mediation well, but make sure the right people are in the mediation, because my only experience of when mediated settlements fall apart or crumble is when somebody goes back and they have reported back to the board. And of course, the board have given them certain authorities based on what they predicted was going to happen during the day, but they weren't there. And then when the individual goes back, they are embarrassed, and in some jurisdictions, they need to save face. And the argument is, well, this is just not what we planned for, we're going to renege on it. That's a nightmare. You can avoid that, exactly as Baria says, if you make sure as mediator that you've got people with true authority and sufficiently senior, that when they've done a deal, that deal is done.
And if I could just mention as well, I mean, the Singapore Convention, I think, brings a different benefit to mediation, and that is that it's a recognition by the signatory states themselves that mediation is a legitimate process. And one of the things I've really seen over the years that I was active internationally was how mediation and the acceptance of mediation has grown globally, whereas, 20 years ago or so, it would have been confined to only a few jurisdictions where it was actually even practiced. Nowadays, it's gone right across the globe. And in most jurisdictions, at least people will know what mediation is. And in many jurisdictions, it's actually utilized. And what the Singapore Convention does, because of course it's a treaty that countries have entered into, it legitimizes the process and makes it actually a process that people feel they can utilize in cross-border commercial disputes.
Right, and I think I should add to that, indeed, it's only applicable if your state, if the member state has signed on to the convention, so that mediators should petition their states to sign on to the convention to make it much more effective. Because without that, then of course, it's not applicable. In keeping with the COVID mindset and understanding that the advent of COVID has severely restricted how we move, no longer face-to-face meetings, but that we need to resolve disputes. We need to allow parties to continue to develop their business models and continue with their transactions. Which brings into discussion the virtual platform that we have all been talking about. Can we use the virtual platform to pursue mediations? Do we have to be face-to-face? Do we have to have parties present with the mediator to be able to effectively try to resolve and arrive at settlements? Jane, you have been mediating virtually. How effective is it delivering results using the virtual platform?
Calvin, I have been amazed. I mean, I think when it happened in March, I think all of us mediators of 50-year-olds plus went into panic mode and thought, Zoom, how does that work? And we spent ages trying to get a handle on it. But now we all do it. We do it almost daily. And I think there's probably not one person that's listening to this today that hasn't done a Zoom, if not a drink with friends, then certainly a business meeting. And I've been absolutely amazed at how effective it is and how much the results have been so positive, both in terms of my skills now, I feel very, very comfortable with it, but also the client experience, the feedback we've got from clients has been so positive. I mean, just look at us now, you almost forget that you are doing a virtual webinar. People feel very comfortable speaking to a camera like this. And at first, I mean, I think a lot of lawyers were very worried that they would not be in the room with their clients, and I completely understand that. And I'm sure I speak for the other mediators here that I spend a lot more time now preparing. I have spent time with the clients and the lawyers together, getting familiar with the way that Zoom works, so that the lawyers feel that they want to control the client. They won't be able to kick them under the table as they could do in a face-to-face mediation if they feel they're saying too much, but they can prepare and they can still run a mediation very successfully. And so lawyers have fed back to me so many times how it's much better than they anticipated it was going to be. There are obvious advantages for Zoom in terms of cost and travel, much so I would love to be traveling to the Caribbean on a regular basis. Think of the cost savings in terms of not having to do that and being able to mediate the international disputes from your own sitting room has been amazing. In practice, it takes less time. It seems to be that mediations seem to settle quicker virtually than they do face-to-face. Flexibility in terms of being able to check on something, to be able to drop off and have a break, to be able to do a mediation over a number of days if there's a high emotion and people need to take stock. Again, so much easier to dial back in than to have to extend your stay, extend your travel, extend your accommodation. And dealing with emotion, I just don't buy it that commercial mediations don't have emotion. They certainly do, just as much as perhaps trust fund mediations or individual mediations have emotion too. And if you are feeling tense, it is so much easier to have and express yourself when you're sitting in your own house, in your own comfort, knowing that you can take some time out, go and make a cup of coffee, come back, regain your composure. I have found that people have been able to deal with emotion, both receiving and giving the emotion of their position much more easily than they would be if they were in what for some people can be a very unfamiliar territory of an accountant or a solicitor's office. Certainly in terms of comfort of receiving food, making sure you get supper, you've got hopefully a partner somewhere in the background who can supply you with food and drink all day. Whereas again, in a face-to-face mediation, you are at the beck and call of whatever hospitality you are and often it's good, of course, but you're still under somebody else's control. I don't think virtual mediations will replace face-to-face completely, but I do think it's a real alternative, and I do think it's here to stay. And I think a lot of commercial entities are going to recognize the real cost advantage of that as being an option available to them going on into the future.
So do you think that there will be certain types of mediations that can or lend themselves to the virtual platform and others that don't? Is that why you say you don't see it replacing face-to-face?
Yes, I mean, I think there are some mediations where you want to go on site. There are some mediations where you might want to explore something from a face-to-face point of view in terms of if it's a big family trust. I think sometimes it's much more helpful to spend some time building trust with individuals where there's a lot of money at stake. But I think on the commercial pragmatic mediations where you don't need to look at the plot, you don't need to, you can understand the paperwork just as easily. And if you did have to get, for example, I did a big hedge fund mediation in July where we had Milan, Brussels, Paris, and London all on one screen. We could all discuss the issues that were going on from a personality point of view that were causing a 90 billion investment to go pear-shaped. We didn't need to be in any one jurisdiction. Nobody particularly wanted to travel to any of those European countries at that time, and we were able to resolve it. And I would suggest that if that happened a year later, we still would have done it online. So yes, I think there are certain disputes that people can always think of now doing them virtually as opposed to resolving them face-to-face.
Okay. Barry, the Caribbean, the jurisdictions are divided by water. As a result, do you see the virtual platform taking off to further mediation in the region?
Absolutely, and I think it makes sense for lots of reasons. So obviously, there's a lot of inter-region trade that historically has taken place and is ongoing and will continue. The jurisdictions rely on each other in so many respects. So that has, in the past, necessitated a lot of regional travel by professionals and business people in ensuring that trade can continue and take place. While it's not nearly as onerous as it once was, interregional travel, for those of you who are in the Caribbean, you'll know it's not easy. It's sometimes easier to get from Barbados to Miami than it is to get from Barbados to St. Lucia or Trinidad. And that's just a fact of having limited options in terms of flight providers, airline providers, etc. Add to the mix COVID. You can't imagine a situation where trade just simply stops. People rely on it too much. So the reality is that the region is already working virtually in lots and lots of ways. This being an example, in a different situation, a different year, we would have been hopefully there in person, talking to an audience in person. So I think there is a real opportunity to use virtual platforms for mediation. And I know that at least the AMCC and a couple of others are looking at putting into place systems which will allow for mediations and arbitrations to be conducted on those platforms. I think I also want to just underline some of what Jane has said about the opportunity that this presents in the longer term. While I also agree that virtual mediations are not simply just going to replace in-person mediations, I think we might now start working with the process slightly differently off the back of having done what we have in the face of COVID. So I find myself now thinking it's almost always going to be the case that I will set up a conference with each of the parties in advance of the mediation. And before COVID, it would have only been usually a call with the lawyers. Potentially in some cases, there might be a site visit, but usually it would have been a telephone call with each of the lawyers. And actually the opportunity that this has afforded us as mediators to start building rapport, to start building the trust and confidence in the process by the clients themselves, to start answering any reservations they might have about the process, about their participation, what they can get out of it. I think it's been such a shift for me in terms of the way that I view that early phase of the mediation. So I think that will always stay. There's also the opportunity, and I certainly in certain types of cases, I find that I have booked with the parties 2 separate days, a period apart, because the first day is focused, for example, on them sharing some information, and then they need a rest period to go and digest that information, and then they want to come back together, having done that, to now negotiate an outcome. And there may be possibilities, even post-COVID, where some of that can be done online and some of that makes more sense to do in person. So I think the results speak for themselves. We've all been massively surprised by how effective it has been. There is no reason why it shouldn't be the same level of effectiveness in the Caribbean region. And actually the fact that the region works in a particular way makes it even more appropriate, certainly in the current environment and circumstances.
I'm surprised that you're so readily accepting that we will go back when the opportunity presents itself to business as usual. I think there's going to be a new normal. I think this platform is going to be an integral part of how we do things in the future. I don't know that businesses would want our lawyers and parties gallivanting around the globe, incurring costs and the likes. But there's a question with respect to costs, which we'll come to. But before we do that, Wolf, what is your experience with the technical aspects of virtual arbitration?
Mediation, yep.
Mediation, yes.
Yeah. Well, it works for arbitration, of course, as well, in much the same way. But I mean, one of the key aspects, and this was recognized early on with Zoom, is actually security of the platform. So you want to make sure that only the persons who should be there are there. So platforms have all become much secure by putting additional security steps in place. So to get into the actual mediation, you now have to put in a password, or you might actually have to identify yourself in some other way. But as Baria was saying, a lot of the institutions now are creating actually much more secure platforms. So our own International Arbitration Center in London that we belong to has now created a much more secure platform that ensures that only the parties that are meant to be there are there. And that is a real concern. That is something that is important. I think the other aspect of it, and as all of us who are mediating at the moment, is that in the mediation agreements themselves, you'll find that there are now additional clauses that are coming into it. And this partially answers, I think, one of the questions that someone had, is who's the provider going to be? Which platform are we utilizing? Is there a cost to that platform? And then how is that cost going to be paid for? Who's going to be the host of the mediation? Because, every platform needs a host. What's the liability of the provider and of the host to the mediation if there's some kind of issue? So these are aspects of the mediation agreement now that have to deal with those questions. As we see here today, we're recording this session. Recording is extremely easy with respect to these platforms. So we have to make sure that it's agreed between the mediator and the parties whether there will be a recording. And if it's prohibited, that it's clear that in the agreement to mediate, there is a prohibition to recording. How about if we look around our screens right now as we're looking at each other, who else is in the room there with you? I mean, how do you know there isn't anybody else in the room there with you? Mediation, as we know, is a confidential process. We want to understand who's taking part in the mediation. So we want to ensure that, again, at the very least, we've covered that in the mediation agreement, and we've actually specified that only persons who are meant to be there and who are listed to be in the mediation are in the mediation. The other aspect is that there are a lot of distractions that people have. I mean, Jane said it's very comfortable to be in your own home, for example, and that's absolutely true. But there are also more distractions than if you're in a physical mediation room. And we want to make sure that there are sufficient breaks, that people are given the opportunity to work on whatever else they might have to do, and that there are assigned times for it. We also know that there's Zoom fatigue that sets in after a number of hours in front of a screen, which you might not have to the same extent in a physical meeting. So one of the things in planning, as Jane and Barya said, there's a lot of time spent on planning before the mediation now, much more than perhaps in a physical mediation. And one of the planning steps and the discussion points in the mediation, the pre-mediation conference that the mediator will have with the parties is, how long do we want our days to be? Do we want an 8-hour day? Or do we want to break it up into chunks? And likely, for all of our experiences now being that you probably don't want more than a 4 or 5 hour chunk of time for people to be engaged in a virtual type of mediation. So the mediation will likely stretch over a longer period of time. So those are all points, I think, that have to be taken into consideration. I mean, on the question of cost, clearly cost and time, a virtual mediation, as Jane has already pointed out, is going to be much more cost effective and time effective, because parties don't have to travel to the location. Even if they're just domestic parties, typically you have to travel to the location of the mediation. So all of that time is saved. And the costs are also thereby reduced significantly. And so I think, as we were discussing before, there will always be a place for virtual mediation, even if we are happy to get back on an airplane again at some point in time. It's just proven to be so very effective and not in any way, I think, less successful in its outcome. So I think we are moving certainly in that direction. Thank you, Calvin.
There is a question about ethics, whether or not an a mediator can be recused, and if so, under what conditions? Anybody?
Well, I think if we're talking about conflicts of interest in particular, and a party being biased, those are all issues that are dealt with at the time of the appointment of the mediator. He or her has to actually set out for the parties whether there are any potential conflicts, because that's something that the mediator either will be asked for expressly, because they will be provided with the names of the parties and the circumstances of the case. And if you can't be impartial as a mediator, then you've lost really the strength of your role as a mediator. And so in those circumstances, the mediator themselves should be stepping back and reclusing themselves from that particular mediation. Or if the parties do determine that, or one of the parties determines that, they will raise it. And this is where an institutional mediation actually is extremely useful, because you have somebody to go to complain about that, and somebody who then can remove the mediator if necessary from the mediation. The others might have a different view.
Well,
Jane Barya, do you have a?
I mean, the only thing that I would say about recusing, about asking for a mediator to be recused if you don't want to proceed with a mediation with a particular mediator, you just withdraw. It's a voluntary process. So if one of the parties is unhappy with the way that a mediator is working with them, then they always have the option to say, you know, mediation for me is over and I'm out. It's not a formal process in the way that an arbitration process might be, where it can become a little bit more complicated. But certainly mediators should be checking conflict when they're being asked about appointments, so that they can be as clear and as open right at the beginning, and that there can't, you know, later come at them some allegations of bias or something worse. And certainly in a situation where a settlement has been achieved and is being reneged on because some conflict has later come up, for the mediator, that's just bad for business, and it's bad for the sector and the profession. So as mediators, I think we have to take responsibility for that right at the outset, when we're invited by the parties to potentially come on board.
I agree. And look, absolutely, you need to iron out getting the right person before you start the day. But I also think, you know, mediation is not a soft option. It's a hard day. It's hard work. And if we're doing our job properly, we are impartial, but we are also going to do some reality testing. It's going to be an uncomfortable time for you. And many, many times as mediators, we get told in one room, I feel as if I'm being pushed too hard, or this feels really uncomfortable. And we have to keep telling them we're being tough in both rooms to make sure that when you guys come to a conclusion that you can both live with, it is the right compromise on both your parts. The funny thing about Zoom mediation is that, as I say to people when I'm starting a mediation in a face-to-face, you know, you can go at any time. As Barry says, it's a consensual process. If you feel uncomfortable, you have every right to walk out. In a face-to-face mediation, I'll often try and stop you if I think you're near to getting a deal, nearer than you think. In a Zoom mediation, I can't. If you want to press that switch and turn me off, you're going to turn me off. I had a very heated mediation last week where one of the participants, who was quite a well-known celebrity, who was very known for his volatility, he turned me off 3 times. And 3 times I had to go back to him by email and say, please, can you join me back again? Everyone else is still here, and I think we're going to get a deal. And we got a deal. And he said to me at the end, you know, I'm so glad that I could keep coming back in. Now, if he kept walking out of the room, or got on a train, or disappeared into London streets, I might not have been able to get him back quite so quickly. So the process is going to be tough. The mediator has to be impartial. We've got a really difficult job on our hands. And I see there's some questions in terms of our qualifications, but we have to maintain flexible, impartial help to both sides in equal measure to help them reach their decision. Nothing that we do or think or say is going to change the minds of individuals of its own. You guys are in mediations helping your clients reach their solutions to their problems. And that's the big difference in mediation. That's why recusing is really a terminology I recognize more in arbitration than I do in mediation. Maybe, Calvin, we could deal with the issue about qualifications.
Yes, which one is that?
It asks whether we are all lawyers, and they're saying, you know, is there yes, there are some very good mediators who are not lawyers. Having said all that, often you're mediating something that may well go into a legal dispute through arbitration or litigation if it doesn't settle. And the ability to understand the risk assessments from the legal point of view can be helpful, but not always. I can see construction disputes that I know are excellent surveyor, qualified mediators who do a super job in the mediation field, and it is by no means just the lawyers who can recognize legal risk. So predominantly, most mediators tend to have a legal background, but it is not necessarily always the case. I don't know what other people think.
Yeah, I agree. I mean, in terms of specialist sectors, for example, employment, you have, you know, a lot of HR professionals who are very actively mediating and do a great job. And you don't necessarily need a lawyer mediator in those scenarios. So it really depends. I think if you do have a niche, area that you practice in whatever way your professional work is conducted, it's always, if you're interested in mediation, it's always worthwhile thinking about how you can maximize as a mediator on that expertise and that niche level of qualification.
Medical negligence is a very good example, isn't it? Where if you're an ex-doctor, or you've got a medical background and you're a mediator, that's very, very helpful. But I would say this, that don't worry too much about having knowledge of the subject matter, whether it's medical, whether it's construction. Our role as a mediator is not to be the expert. You've probably got fantastic experts on board. Indeed, you lawyers will know much more about your case than we ever will. And therefore, I'm always cautious, even though I'm a lawyer, in pushing back too much on the legal analysis, because that's not my job. My job as a mediator is to give you an environment to have the discussions you need to have with the other side, so you can risk assess. So I'm always a little bit cautious about suggesting that people need to be specialized in the sector or the subject matter. We need to be good mediators. That's the key skill we have to have. And I'd rather have a better mediator who may not know about my area than have someone who knows the area really, really well, but can't mediate for toffee.
And actually that goes hand in hand with something that was raised earlier, which is in relation to, I think one of the questions was talking about, well, you know, as lawyers, as mediators, do we like having lawyers in mediation? And certainly my preference is to have them there, particularly on technical disputes, because they are the technical expert for their client, there to give their client that advice. And if I am a technical expert in the same field and there are no lawyers present, suddenly the clients are looking to me in a different way, which may have an impact on me retaining my neutrality, me retaining my independence as the mediator. So my preference is to always have lawyers present and to be able to pass the buck back when it comes to advice to the lawyers, and work with them in that way. Can't hear you, Wolf.
Yep, sorry. I was going to say, in fact, that's a great point, because lawyers can be extremely effective in mediation. It's just that they have to learn how to do it. And you know, I've been teaching some courses on mediation advocacy to lawyers where they learn how to utilize the mediation process to the advantage of their client and get much better results in mediation. And that's where lawyers can really play a very important role for their clients, but they have to understand that it's a different process than the actual litigation or arbitration process, and their role in interfacing with the mediator and using the mediator to help them to actually get to a resolution are extremely beneficial for their clients. So I think, you know, lawyers are essential to the process. They just have to understand how it works.
Indeed, at the Club Español de Arbitraje in Madrid, we've come up with a set of guidelines, soft law, good practices, where we indicate that lawyers do play a very instrumental role in pursuing objectives of the arbitration process, and indeed do play a role in encouraging their clients to conduct themselves in a manner that's constructive to reaching agreements during the mediation process. So there is a very active role, I would have thought, for lawyers in the process. There is one question that I think, Barya, I think you can include it in the response to the question I'm gonna put to you. And that is, you know, having spent some time in the region, setting up the AMCC, for example, do you have some tips on how to increase the use of mediation? And that goes in nicely with the last question that was posed. And what are your thoughts on bypassing mediation in favor of adjudication? And then the second part of that question, the ADR field in the Caribbean being tightly held by established, experienced hands. What advice would you give for a qualified media or arbitrator with limited
Yeah.
experience access?
Okay, well, I'm going to pick up one of those questions, not all three of them, otherwise I'll be talking your ears off for too long at the end of the session. So let me just start by, you know, the potential to increase commercial mediation in the region. I think institutions are a great way to multiply the message as broadly as possible. And the Caribbean now has the benefit of a number of institutions all working towards the same goal. Yes, they want to get work as individual institutions, but they also want to elevate the Caribbean as a region in terms of its use of ADR. So there's an opportunity, I think, for, you know, recognizing that there is a level of competition, but that the collaboration that can happen to help raise the number of cases being referred to mediation and arbitration is a real sort of opportunity in the region, unlike a lot of other regions, because these are small jurisdictions. We've touched on conflict. Conflict plays a part very much in smaller jurisdictions because everybody knows everybody. So, you know, there are ways in which that independence can be assured by the regional organizations and institutions working in partnership and in tandem. So I think that's one way in which use of mediation can be promoted collectively and cooperatively. The other things that I think, or ideas that I think are worth bearing in mind, is where do you find the most disputes? And there are often, what you want to do is normalize the use of mediation, right? And any new emerging country where ADR is still pretty new and fresh, or in this case, a region, what you want to do is to start people thinking of this as a normal part of the dispute resolution spectrum, of all the options available to them. And one of the easiest ways of doing that is by introducing it at every tier. So not just focusing on the big international multi-party, very complex, multi-million-dollar, you know, contracts, but also thinking about what other tiers can mediation actively help in. So schemes for insurance sector, you know, high volume, low value cases, which are automatically being sent to mediation by agreement by sort of, you know, within the contracts, the insurance contracts, specific reference to mediation in the case of a dispute, and that those schemes are being run by certain institutions. It's an easy win. It just requires a relationship to be built between the institutions and the insurance providers in that example. Lawyers working with lawyers, obviously there's you know, there is sometimes a reluctance to utilize a process like mediation if you're unfamiliar with it. Certainly when I was in practice, you know, that would have been something that I was worried about. How am I going to look in front of my client if I don't know how to protect them and their interests in this process? And so education for lawyers at every stage, from UE and the undergrad courses all the way to practice and continued professional development, doing courses like the one that Wolf referred to on advocacy and mediation for senior lawyers, I think would be really useful, because the more that they understand its value and understand how it can have a positive impact on their business, not just on their clients, which is what Jane was talking about, you know, repeat client referrals, because clients will always have disputes. But if they're happy with you as their lawyer this time, they'll instruct you again next time and the time after that. So working with lawyers in making them feel safe and secure in using the mediation. And then finally, another of the topics that we've already picked on, you know, encouraging commercial lay clients to really start looking at transaction level, incorporating ADR and mediation into their contract clauses, and the value of doing it at that point. So I think there's lots of opportunities, and it's really the key to it for the Caribbean region is a collaborative approach, because working in silos, you're not going to be as effective as you can be coming together as the ADR community, as the legal fraternity, as the commercial sort of backbone of the region, to say we want this because this is going to have a positive impact on the way that we work and the way that we grow.
Is it necessary to have mediation legislation to have mediation flourish?
That's a closed question. I'm going to say no.
Wolf?
But I've spoken enough. Wolf?
Well, it's an interesting point. I mean, if you look at Europe, most European countries actually have legislation. But oddly enough, I mean, if you look at England, it doesn't have specific legislation. There is a EU directive on cross-border mediation, which has had to be implemented throughout the EU and also in England. But I think it's a mixed bag. You look at the United States. I mean, some states have legislation, some states do not. It's something that isn't necessarily needed for mediation to flourish. One could even argue that in some cases, it's actually prevented mediation from really taking off. So I guess it really depends on the culture in a particular country as to whether everything is highly regulated or not. And so, but I don't think it's needed for mediation to actually take off.
Okay. Any parting comments?
No, I agree. I mean, I think one of the things that Baria mentioned is really interesting, and it hits to that last question on the chat. We need to normalize mediation. Mediation should be something that we don't have to keep asking what is it, or confusing it with arbitration. It needs to be something we're all so familiar with that it's an obvious to go to, particularly for SMEs. And I think these schemes where insurers back mediation, where the travel schemes have been fantastically popular, is a way both of junior mediators, young mediators, to get involved. They're lower value, and therefore they're easier to be able to get involved with. They're ways of which we'll see mediation becoming much more mainstream, and we're seeing it in so many different jurisdictions now that I think in 5-10 years time there won't be conversations around what is mediation. It's more around, gosh, mediation is becoming pervasive. It's actually in every sector, and it's being used on a regular basis, and that will be good for business. It will be great for lawyers, and it will be very good for new mediators too.
What hasn't been said in my parting comment would be the contribution that ADR, including mediation, has on court dockets. If indeed we start from the premise that about, I would say, 60% of cases that are on the court dockets don't need to be there. And so that if we start from that premise, then obviously access to justice requires that these litigants have some resolution to their dispute. Then the question is, what mechanism? And I think that mechanism is ADR, including mediation. I think particularly the complex commercial disputes should contemplate tiered clauses, which would indicate or include mediation as one of the tiers. As the panelists point out, there ought to be specific references to how much time a particular tier has to be pursued before you can move to the next tier, essentially with the concern of one of the members of the audience about how courts would treat the mediation. I do know that in treaty arbitration, for example, there are disputes in our litigation whereby courts are asked to determine whether or not parties are obliged to mediate prior to going to arbitration. And is that a contractual obligation to the extent that you must do it? And if you don't, then of course the jurisdiction question for the arbitrators then of course is put into question, because you have not complied with a particular requirement of that dispute clause. So I do believe that mediation has a very, very bright future, particularly in the advent of the Singapore Convention. I do believe that we should be petitioning countries to sign on, because as we point out, the discretion to not honor arbitration agreements is removed if countries are signatories to the convention. Courts then are obliged to recognize the treaty obligations of that particular state. And of course, any discretion, therefore, would have been removed or addressed by the convention. Those are my parting comments. And I don't know if the panelists have any other further comments. Those of you who don't know me, my name is Calvin Hamilton. I'm an arbitrator. I'm a member of Int-Arb Arbitrators and Mediators. I've been at the ADR for over 3 decades. And during my time, I have seen a lot of cross-border transactions where we have used tier clauses to address concerns about a dispute resolution, and have been doing it for years. The question I asked about whether or not legislation is absolutely needed to pursue or to further mediation, I agree with the panelists that it's not necessary. We've been doing it for years, although in Europe there is mediation legislation. I don't think that it is absolutely necessary that we have it to be able to pursue mediation. And I say that in the context of the Caribbean, that we can go forward and continue to go forward with good practices. Education is an integral part of the process. Buy-in by the business and other sectors is crucial. I believe that we're seeing that in the Caribbean through the good work of Barrier at AMCC, the BVI, IAC, Jamaica Arbitration Institute has also been doing good work in this area. So we've seen in the Caribbean that we are making strides with respect to ADR, including mediation. So I think this panel discussion was quite timely. And I encourage listeners, attendees, if there are any questions that we may not have answered, or any of the issues that concerns you that we may not have addressed, please feel free to write to us, and we'll be happy to get back to you as soon as we possibly can. So with that, I have no other or further ado but to thank the panelists, Barrier, Wolf, Jane, thank you very, very much. And of course, to Int-Arb and the International Arbitration Center for lending their platform, their technology platform to this session. And I look forward to seeing you all very soon. Good afternoon.
Thank you very much.
Thank you, Calvin.
Bye, everyone.
Bye-bye.
Thank you, bye-bye.